So this first panel is on the rules-based international order and public international law. And I accepted to chair it mainly because I wanted to find out what on earth was supposed to be the difference between the two things. I am a strong sympathizer with Professor John Dugard, I would have to say, and with whoever said ditch the rules-based international order, because I tend to think that, well, we have perfectly good public international law. Why don't we refer to it? But then again, I'm an open-minded kind of guy. I can accept that there might be something in this. So then I thought, well, does it perhaps include the institutions, in which case, I guess speaking of international law might not capture that. But then I began to think, well, why then don't we speak of the international legal order instead of the rules-based international order if we want to take in the institutions? But then I reflected, well, maybe we're talking about non-binding norms. But then being a steadfast Kelsenian, Hartian positivist, I thought, well, then we're not talking about rules if we're not talking about law. That said, some so-called soft undertakings can indeed be enforced, as we will be hearing a bit in one of the speakers' interventions today, provided, of course, provision is made for that. So, coming back to the main question then, is there a difference between the two things? What is their relationship? Is the one just another way of saying the other, but saying the other in a way that is perhaps catchier and able to be sold a bit better? Well, these and other questions, I guess, we will be batting around in our first panel. We have four eminent speakers: Dr. Kenneth Chan, Dr. Yurika Ishii, Dr. Kathryn Nash, and Dr. Debra Long. I will introduce each of them in turn when they come to speak. The last three will be speaking on more specific topics within the general topic. But our first speaker, Dr. Kenneth Chan, a research associate at the Walther Schücking Institute of International Law at the University of Kiel, will be speaking more generally on the rules-based international order as a concept. So without further ado, and asking everyone to keep to 10 minutes so we have time to chat, Kenneth, I ask you to take the virtual floor.
Great. Many thanks, of course, to Birkle, to Yolanda and Iris for this kind invitation to participate in today's discussion. I think it's really a fantastic opportunity to reflect on the implications for us as members of the international community at a time of really heightened geopolitical instability. So I'm going to take up Professor O'Keefe's questions. I think that's very much the sort of main theme of my discussion today. There are, I think, a lot of questions and a lot of things that we don't know about the rules-based order that we should be asking. And really, I think at the top of that list is, what is the rules-based order and why do we know so little about it? In fact, if we think about it, we don't really know what purpose it serves or what purpose it's intended to serve, and what and whose rules are being applied, what systems and institutions and norms and principles are part of this framework. We don't know who exactly are its members or what the criteria is for membership, or what roles these individual members serve. Are there, within the structure of the rules-based order, rule makers and rule takers, or is there some kind of egalitarian structure that the regime applies internally? We don't know, do the members of the rules-based order even really share the same understanding of the framework and its contents? And some of these statements by different governments referring to rules-based order suggest that this is not always the case. And really, as international lawyers, I think the main question for us is, how does this regime engage the existing international law framework? So obviously, these are all, there are a lot of questions that we can't really answer today, but perhaps more importantly, we don't really have the information available to answer these questions effectively. So what I'd like to do is just offer a few short observations about some of the key conversations I believe will be of greatest interest to this audience. And I'd like to start by really just reflecting on what do we actually know about the rules-based order as opposed to what is implied about the rules-based order by its proponents, or simply assumed by us as consumers of the concept. And there are a couple of things that we do know. So we know that the rules-based order was not a term that was very strongly engaged with within international relations until the turn of the century, when sort of the first sort of major use of the term was by the US justify its invasion of Iraq, which really happened without Security Council authorization, as many international lawyers know. So really from an early stage, we can already see the pivot that this term takes from the parallel normative framework of international law. And we see that the rules-based order really became a central narrative in US foreign policy under administrations of President Obama and Biden. And therefore, that was when it really found its favor with America's allies, who are the primary members of the rules-based order. So in this sense, the rules-based order is an imagined community populated by Western liberal democracies and their allies and aggregated institutions. That's sort of the common understanding. And that includes Australia and New Zealand, Japan, Canada, France, Germany, Kenya, the EU. And what we can sort of surmise about this community in general is that what holds these states together is a deep and shared commitment to certain particular values like the rule of law and human rights and so on. But what's important is that all of these particular values can be generally understood as aspirational and ideal global public goods, but not all of these rule-based order goals are universal, and not all states share the same view as to how to achieve them. We don't really know yet what the full scope and substance of the rules-based order actually is, because some or all of the countries within the order are currently and actively in the process of creating, interpreting, and redefining the rules and institutions that make up its substance. And it's applying existing hard law and soft law rules and norms of public international law and moral norms and all these kinds of different areas of behavioral modifiers that we don't really fully understand yet. So the information that we have about the rules-based order is really being released in a piecemeal way through statements of governments, heads of states, and senior officials, and that creates what I think is a very incoherent picture of what the rules-based order is. And one of the consequences of this is that we don't really fully understand how these rules are being constructed. Is there, for example, an internal hierarchy or organization within the regime through which norm conflicts are resolved? And how are hard law and soft law rules implemented? And is there some form of hierarchy or structure to that? And in particular, because we were talking about the rules-based order, we should also be aware of the possibility of that the rules-based order is engaging with these ideas and these structures and processes through their own sort of hegemonic perspectives of the world, and applying existing rules and norms through that particular point of view. So in this sense, this sort of lack of understanding about the contours and shape and nature of the rules-based order really makes it very difficult to conceptualize and also to contest, because we don't know what we are responding to. So that being said, I really wanted to focus on what is the sort of nature of the relationship between the rules-based order and public international law. And I think how I would begin this is by saying that there is often some confusion because state proponents of the rules-based order frequently strongly imply that the rules-based order enjoys the legitimacy of international law because it upholds the international legal order. And we really see in these statements, especially by the US State Department foreign policy, that frequent references are made by states to and about international law. But in those statements, advocates are very careful not to say that what the rules-based order actually does is applying international law wholly and exclusively. So that really we see this idea implied in the actual name itself. It is a rules-based order. It gives a very distinct impression that it is has some kind of legal legitimacy. But we also know that international law doesn't recognize rules-based order in any international treaty or any international instrument. So if the rules-based order was only about international law, then as Professor Keith points out, then we would be calling it the international law-based order. And I think this deliberate use of terminology of a rules-based order it's really because states of the rules-based order don't want to be bound by the terms of public international law that are inconvenient to it, but want to enjoy its legitimacy through association. So they want to be rule makers and not rule takers. And what they especially don't want to be bound by is the consensual structure of public international law. The problem with committing, I think, to public international law only in part, and the parts that the rules-based order members like, rather than committing to public international law as a whole, is that this is really insufficient to uphold international law as a regime completely, because defending international law or upholding international law really requires that it's either all or nothing. It is in the part of international law that states in the rules-based order aren't committed to, where the stability of the international regime is really at risk, because that's the part where states determine their own rules and norms. And in the case of the rules-based order, attempts to foist these new ideas, unfamiliar ideas, on other communities of states. So if the rules-based order is not simply public international law by another name, what is the exact relationship between rules-based order and public international law? And I think as a couple of people have rightly pointed out, the rules-based order has been perceived as seeking to replace international law with some kind of alternative regime. And this is, I think, a reasonable assumption to make, but it also could benefit from a little bit more nuance, because we don't really know exactly if that's the case. We don't know if the rules-based order is intended to replace public international law, or to supplement it, or to parallel it, or to directly or partially engage with it, or contest international law. And this really requires further investigation and interrogation of a number of different factors, which I won't go into today because of time. The rules-based order, I think, then, if it's not about the direct promulgation of international law, what do we think it's about? And on the one hand, we could sort of assume, we could give the benefit of doubt to states and say that we recognize that international law is not a perfect framework, and amongst its deficits is its lack of adaptability. So the rules-based order could be seen as filling gaps in public international law. For example, public international law doesn't really have much to say at the moment about the regulation of autonomous weapon systems. And so there are fundamental disagreements between great powers about this, and rules-based order can help to fill that situation. But we also know that states have claimed that the rules-based order does more than this and applies to situations where international law already exists and already applies. So quite rightly then, critics have said, well, maybe this attempt to disrupt the continuity of public international law is more about control and power within the multilateral order. And the rules-based order, I think we should understand, it really has gained importance in contemporary international relations at a time where Western legal and political authority has diminished, and great power rivalries similar to the geopolitics of the Cold War are rising again. So in no certain terms, when other powers like China and Russia criticize the rules-based order, we should understand it's because they want their own rules-based order, which they have autonomy and control over. The ability of hegemonic powers like the US to cast influence over other states is changing. So the rules-based order could be understood not as an attempt to address gaps of international law, but I think also could be understood as sort of about the administration of empire. And so we don't really have time to explore it right now, but I would just say that the fraught relationship between the global north and the global south, and for example, Africa's engagement with the International Criminal Court, all points to this possibility of this sort of hegemonic character to the rules-based order and the hegemonic intention there. So I will leave my comments at this. Thank you very much.
Kenneth, thank you very much, not only for keeping to time, but really for summing things up in such a sweet, succinct way. In some ways, you've confirmed my prejudices insofar as you suggested perhaps it's a Western, not a universal concept, which is, of course, the criticism most often heard, including from China and Russia. But then you're very provocative and it seems to me at first glance, a probably correct statement that, well, perhaps China and Russia just want to construct their own selective rules-based international order. The whole idea, whichever way you look at it, being, it seems from what you said, that hegemonic powers want to be rule makers, not rule takers. However, you suggested, and I agree, we give it the benefit of the doubt. So then, giving it the benefit of the doubt, let's hand over to Dr. Yurika Ishii, who is the associate professor at the National Defense Academy of Japan. She will be speaking on customary international law and the UN Convention on the Law of the Sea, with particular reference to recent case law. So Dr. Ishii, please, we hand over to you.
Thank you so much, Chair. Let me start by thanking the organizers of this event. It is my great honor and pleasure to be a part of this forum. So let me share my slide. So I will talk about the concept. Sorry, I hope you're looking at the slide now. So today I will talk about the concept of the comprehensiveness of the UNCLOS, the United Nations United Nations Convention on the Law of the Sea, and the recent case law held by the ICJ. So let me start by introducing the summary of the judgment. As many of you will know, the ICJ held that there is a customary international law rule saying that the states may not extend its continental shelf beyond 200 nautical miles from the baseline from which the breadth of its territorial sea is measured to the other states 200 nautical miles continental shelf. So in this case, it was Nicaragua which claimed the extension of the continental shelf into the Colombia's 200 nautical mile continental shelf. Colombia is not a party to the UNCLOS, so the court held based on the customary international law, and it looked at the practices of the member states of the UNCLOS and held that there's a rule saying that Nicaragua cannot extend its entitlement into the 200 nautical mile. So my question here is that whether the ICJ rejected the idea of the comprehensiveness of the UNCLOS. So to examine this question, I will briefly introduce the contents of the comprehensiveness and its basis and its arguments. And then I will briefly look at the Nicaragua-Colombia case. So as you may know, UNCLOS divides maritime zones into several areas, such as territorial sea, EEZ, high seas, contiguous zones, and etc. Now, the comprehensiveness of the UNCLOS means that the UNCLOS decides the maritime zones that the states can claim. Okay. Which means in other words, the establishments of maritime zones is not recognized if the UNCLOS does not provide that zones. Furthermore, it implies that the convention supersedes any historic rights or other sovereign rights or jurisdiction in excess of its limits imposed therein. So there are pros and cons for this idea. Now, UNCLOS is first adopted as the constitution of the law of the sea. As you know, prior to this convention, there has been really the segments of the treaties. So the UNCLOS was adopted in order to overcome those fragmented treaty laws and provide the constitution of the law of the sea. And also the constitution, the UNCLOS provides the provision that when countries accept the country becomes a party to the UNCLOS, it cannot make reservation to any provisions unless the convention provides otherwise. The purpose of this purpose of this concept or the idea is to preserve the freedom of the seas. The fear is that the coastal states might claim excessive claims, or excessive entitlements of the seas, although the UNCLOS does not provide that idea. And this idea was explicitly endorsed by the South China Sea Arbitration of 2016. However, the UNCLOS does not provide the idea of comprehensiveness in an explicit manner. It was never explicitly endorsed by the ICJ and the ITLOS, International Tribunal for the Law of the Sea. And there are many countries that claims the maritime entitlement that does not have their basis under the UNCLOS. So view is that the comprehensiveness of the UNCLOS will function to prevent the creeping jurisdiction and to preserve the freedom of the seas. And as a result, I believe that it will strengthen the rule-based international order at sea. However, as I mentioned, excuse me, to show the example of the excessive claims, let me show the concept of the mid-ocean archipelago. So mid-ocean archipelago means that the coastal state can draw a baseline surrounding the group of islands, although it does not satisfy the geographical conditions that are provided under the UNCLOS. Recently, China has claiming that kind of baseline surrounding Spratly Islands at the South China Sea. That was explicitly denied in South China Sea arbitration in 2016. However, the Chinese scholars claim that China has its basis on the customary international law. There are a number of countries that do similar establishment of the baselines surrounding the groups of islands. So my question is whether the Nicaragua-Colombia case would have any impact on this debate. Now, as you know, the court held at least two points that is not recognized, at least explicitly recognized under the UNCLOS. The first is the basis for the entitlement of the continental shelf. Now, if you look at Article 76, paragraph 1 of the UNCLOS, it says that when there is the natural prolongation from the baseline, then the continental shelf extends to the outer edge of its margin. The court said, well, so there's the debate regarding the interpretation of the spirit provision, which I will not get into at this moment. The court said that there is two distinct bases for the entitlement of the continental shelf. One is the distance criteria, and the other is the natural prolongation, which somehow does not match with the text of Article 76. The other issue is, as I mentioned, that the maritime entitlement within the 200 nautical mile continental shelf of the opposite state. The court first look at the interrelationship within the EEZ, which recognized, of course, the 200 nautical mile sovereign rights of the coastal state, and the continental shelf. Now, if you look at the history of the UNCLOS, there's the in EEZ and the continental shelf, which are a distinct regime of the law of the sea, because it wanted to some of the maritime states wanted to keep their continental shelf beyond the 200 nautical mile, and therefore there has been two distinct regimes. However, the court looked at that interrelationship is closely intertwined, and it held that there's the distinction between the continental shelf within the 200 nautical mile and beyond the 200 nautical mile. Now, the court noted that the reasoning set above is premised on the relationship between the extended continental shelf and the EEZ and the continental shelf within 200 nautical miles from the baseline of another state. So I think this part requires a close reading, whether it opened the door for the customary international law that deviates from the UNCLOS, because if one can read this passage that court stick to the the idea of the integrity of the UNCLOS, and it did not open the door for the excessive maritime claims, and therefore it did not have much impact on the issue that I mentioned earlier, such as the mid-ocean archipelago. But I think that the this part of the judgment requires a closer look in terms of the comprehensiveness and also the rule-based order at sea. I will stop here and thank you so much for your attention.
Thank you very much, Dr. Ishii. Okay, my screen is back now. I didn't know whether I had lost myself or someone had lost me. It's usually that I've lost myself with these computer things. Thank you. So the question, of course, therefore being the comprehensiveness of the constitution of the seas, its relationship with customary international law and with various other mechanisms. We now move on to Dr. Kathryn Nash, Chancellor's Fellow at Edinburgh Law School. She will be speaking on the contribution of regional systems of international law to universal international law, that is, to international law generally speaking. I will hand straight over to you, Dr. Nash.
Thank you very much, and thank you for the invitation here today. So it struck me while Kenneth was speaking that I should probably kind of define how I'm viewing these concepts before delving into how I view regional systems contributing to them. So I tend to take a broad view of what encompasses the rules-based international order, looking at, as was mentioned earlier in the day, kind of norms, treaties, and agreements that can set expectations. But I do think that these concepts can very much contribute later on to public international law and kind of a more codified version of law. And I compare regional systems, mostly looking at regional organizations and regional courts. And today I'm going to speak specifically about Latin America and Africa, but I think that there are kind of other contributions from regional systems. But two of the most interesting, I think, are the Latin American contribution to human rights international law, and then the African contribution to peace and security. So when it comes to Latin America, I mostly look at the Inter-American Court, or the Inter-American Human Rights System that encompasses both the Commission and the Court. And historically, you have significant contributions from the Latin American system that contributed to our conception of economic and social rights, that fed directly into the Universal Declaration of Human Rights. The American Declaration was signed 8 months prior to the Universal Declaration, and there is significant scholarship from Kathryn Schücking and Paulo Carroza that traces the influence of Latin American jurists to getting specific concepts into the Universal Declaration. I think more currently, looking at the Inter-American Court, there's been several areas of law that the Inter-American Court has been crucial in helping to extend. Just to mention two are amnesties. So looking at the prohibition of amnesties in kind of a post-conflict or post-atrocity system. And I think this has had a significant influence on the practice of peace agreements. So at the Edinburgh Law School, there's a program called Peace Rep that looks at the practice of peace agreements. We have a database of all known peace agreements since 1990. And you kind of see significant I think, evolution or understanding of how we can use amnesties and how we cannot. And then the second is Indigenous rights, specifically the concept of ownership and how we view the ownership of land and how you deal with recompense for historic injustice and not just injustice that dates back to the current era. So those are two that I'll mention in that regional space. And then when it comes to the African contribution to peace and security, I'll be mostly focusing on the African Union, but naming a few specific individuals. And I think Tieko and Coleman's book, African Actors in International Security, which has chapters that deal with specific issues, is a really good volume on this topic. But dating back to the ECOWAS, so the West African Sub-Regional Organization's intervention in Liberia in 1990, which is the first, as I can see it, in the post-Cold War era, non-consensual intervention in a civil war context that predated any kind of Western utilization of this concept or responsibility to protect, or how we conceptualize responsibility to protect today. I think was a very important practice that fed into the development of responsibility to protect, which is underpinned by Francis Nang's scholarship on sovereignty as responsibility. And then kind of looking at advocacy from the African Union, you see a decades-long diplomatic push to reconceptualize how we understand the primacy of the UN Security Council and how we understand the role of Chapter 8, so regional arrangements in peace and security. And the African Union has advocated for a shift from looking at the relationship between the UN Security Council and regional arrangements from one of primacy to one of more cooperation. This has resulted in the United Nations establishing an office to the African Union. It's resulted in significant, I think, practice that has looked at a division of labor between the UN, the African Union, and the 8 recognized RECs, so regional economic communities, the sub-regional organizations that participate in peace and security, and kind of extending our understanding of subsidiarity and how this applies to the peace and security issues and dealing with conflict. And then it's also been seen most recently in December 2023, so just a few months ago, when the UN Security Council passed a framework for the funding of African peace missions. So there still needs to be some details worked out, but I think these are concrete examples of how significant diplomatic pushes, advocacy, as well as practice has really reconceptualized how we understand the UN Charter and how peace and security is practiced globally. And you see this not only within the region of Africa, but also with the resolutions, the frameworks, the practices that the UN Security Council has adopted. So I think it's really important to not just see the rules-based order, and then from that, public international laws being constructed by Western actors, but taking more of an in-depth look at how regions, and I'm sure that there's many other actors beyond regions, NGOs, individuals, contribute to these concepts. So I'll leave it there and look forward to the discussion.
Fabulous. Thank you very much for that. Yes, I mean, historically, it's always interesting to go back and to see quite how much Latin America contributed to general public international law in the, not only in the human rights context, but equally some early movements in the democratic sphere and so on and so forth. And of course, Africa now, and it will be interesting to see what the reverberations of then the democratic backsliding in West African or Sahel states, the broader impact it may have on international law, given what has been the positive impact that has been that it has been making to date. More of that later, perhaps. Okay, our final speaker, Dr. Debra Long, the International Policy Manager at the Law Society, will be speaking on the presenting aspects of the results of 2 research projects in which she was involved with Rachel Murray at the University of Bristol. She will be speaking on implementation of decisions of the African Commission on Human and People's Rights and the African Court on Human and People's Rights. Not just judicial decisions, but also equally non-binding decisions. So we hand over then to you, Dr. Long, and listen with pleasure.
Thank you. And also thanks for the opportunity to contribute to this debate, which I think is a really important one. So as Roger mentioned, I'm going to be speaking about two research projects I've been involved with. These have looked at the issues of implementation of decisions, perhaps to be described perhaps more broadly as findings of the African human rights system. And these research projects looked at the factors that inform the extent to which states implement them, as well as the extent to which other actors, such as civil society organizations, lawyers and judges, actually use them to inform their own actions and advocacy, and to try and influence state behavior. It's linked to a point that Ken mentioned actually in his opening presentation around sort of how hard and soft law are implemented, and also any perceived hierarchy between them. So when I mention findings, what I'm referring to really is a broad range of outputs, both binding and non-binding, from the African human rights bodies. So this includes things such as judgments on cases, decisions on individual communications, provisional measures, thematic instruments, thematic and country resolutions, also recommendations from country missions, advisory opinions, and general comments. So quite a big range of things there, very different, but actually with a common aim, which is to influence state behavior. So within this work, my research examined the related theme of enforcement and how the African human rights bodies have interpreted their role to follow up and monitor implementation of their findings, and identified the opportunities and challenges for them to apply this role in practice. So the first research project was looking at the factors that influence the use and implementation of so-called soft law instruments of the African Commission. This research took as a case study the guidelines and measures for the prohibition and prevention of torture and other forms of ill treatment, the Robben Island Guidelines, really to examine the extent to which they were being used, in what context and by whom. Now, with these types of non-binding instruments, some scholars and activists argue that if they were binding, this would translate to an increase in implementation or use, and that was something we wanted to try and look at. They are perceived to be perhaps weaker, perhaps less useful instruments than binding ones. However, one of our key findings was that stakeholders make very strategic decisions over the instruments they implement and use, not necessarily based on their legal status, but rather often upon their utility in serving a particular aim. So non-binding instruments were used when they fill a gap or elaborated on an issue, or if they were more specific than binding ones. Accordingly, there have been attempts by various stakeholders, as well as the African Commission on Human and People's Rights itself, to try and assign these types of instruments with a binding character in the hope that this would translate to greater implementation or compliance. However, we found this in practice to be an unnecessary argument and strategy. Notably, we found that the level of ownership demonstrated by the African Commission is particularly relevant to the extent to which their findings actually gain traction at the domestic level. Our research significantly revealed that the African Commission has failed to reference and use its own findings systematically and strategically within its own procedures. Consequently, among stakeholders, we observed there was a lack of knowledge of the work and output of the African Commission, or a lack of confidence in using the findings if the African Commission itself was not. Interestingly, there also appeared to be a distinct preference to use international standards and mechanisms instead of those of the African Commission, despite the rhetoric around the importance of the regional character and focus of those types of instruments. This appeared to be because the international standards were better known and were perceived to have greater utility for stakeholders because of their international character and mechanisms. For example, they were perceived as more likely to gain attention from the media. Linked to this, the second research project was sought to explore the perceived implementation crisis affecting the regional and international human rights mechanisms, which really seemed to be undermining their integrity and perceived legitimacy. In response, the regional and international bodies have been pursuing efforts to strengthen the mechanisms for monitoring implementation of their decisions or judgments. Therefore, in this research, we sought to better understand what happens post-decision and the factors and actors that influence whether states implement or not. The project tracked selected decisions and judgments from the African Commission and Court in 3 jurisdictions in Africa. This included Cameroon, Burkina Faso, and Zambia. But the research project was broader than that and did also look at decisions and judgments from other regional human rights bodies, as well as the UN, concerning countries also in Europe and the Americas. Often, the people we interviewed assumed and stated that little or nothing had been done to implement the judgments or decisions. Publicly available information seemed to support this. However, through our research, our overall conclusion was, with respect to the cases that we examined, there was in fact greater implementation than is made visible. We found that countries we examined appeared to take some action on most cases, although the process of providing reparation is slow and is often difficult to gauge and verify the actual level of implementation because of a general lack of visibility. For example, sometimes states had provided compensation to the victims, but didn't want to publicize it for fear of encouraging other similar cases. In the instances where no action had been taken or action had been taken that was contrary to the decision, those cases tended to be very highly political or complex to resolve. Our findings also underscore the understanding that implementation is a multifaceted process. Judgments and decisions and recommendations from the regional and international bodies are directed to the state, but this is not a single entity. Among others, it's composed of the executive, which also encompasses different ministries and departments, includes the legislature, the judiciary, prosecutors, and other administrative bodies and tribunals, all of whom will have a role to play in implementation to a greater or lesser extent, depending on the issue. However, we noted it's not always clear whose responsibility it is at the national level, within or outside government, to pass on information on the case or its implementation. So to summarize our main findings from this very big research project, the following factors were found to be significant for the implementation of decisions or judgments. Visibility is important. In general, we found the more visible the decision or ruling, the greater the likelihood of it being implemented. We also found that it's unlikely to be a one-size-fits-all approach to implementation of a decision or judgment. Instead, there is a need to understand the political context in which it takes place, the nature of the rights violated, whether dialogue or some greater degree of enforcement is suitable, and the sources of pressure that the state is most likely to respect. Now, that requires an understanding and familiarity with the situation in the country and engagement with a whole range of national actors, both pre and post decision or judgment. We also found that the existence of adequate state institutions with a mandate to monitor and coordinate implementation efforts also enhances compliance with the reparation measures. We also noted pressure from donors and the UN or the regional political organs on the respondent states could also foster implementation. We found that there is a presumption that greater specificity would help implementation of a decision. However, we found in practice, specificity might help implementation if other factors are also present. It wasn't the deciding factor. We found examples where states have taken measures to implement very vague recommendations for reparation, as well as numerous examples of where more prescriptive decisions have been seen to be difficult to implement. Although we noted there needs to be some process somewhere to unpack the decision or judgment to work out what is required to implement, who needs to be involved to action it, but that doesn't necessarily have to be the role of the body handing down the decision or judgment. We also recognise that some decisions or judgments may never be implemented fully immediately, but many of them could be implemented at least partially or over a period of time ultimately be implemented in full. So what then is the importance of these findings? So I think the perceived effectiveness of the African human rights bodies, along with the other supranational human rights mechanisms, is often assessed by the extent to which their findings are implemented. There is a criticism that a lack of enforcement mechanisms makes them weak and contributes to a lack of implementation. Yet, some commentators have cautioned against using rates of compliance to measure the impact of supranational bodies, and our research would seem to support that. Par Engstrom, for example, argues there is a need to go beyond conventional compliance perspectives on international human rights, asserting that aspects of their impact, such as the internalization of mechanisms and norms in domestic political and legal systems, cannot be captured by rule compliance models looking at implementation. Hand in hand with this, there is an assumption that states are more likely to comply with legally binding judgments than non-binding decisions. This position has led some commentators, and as I mentioned, at times the supranational bodies themselves, to try and harden the decisions, asserting they are in effect legally binding, or at least comparable to judicial decisions. Yet the research I've been involved with has found evidence of perceived soft law findings of the African Commission being used to implement state behaviour. We found that in those instances where a state has complied either fully or partially with a decision or provisional measure of the African Commission, the reason for compliance has not necessarily been because the state considered itself legally bound to do so, but other factors were at play. I think this is interesting for the debates on rules-based international order, because our research has demonstrated that a wide variety of sources of international law are used at the domestic level by various actors, including state actors, to influence state behaviour. Now, they may cherry pick which ones to use, implement, and comply with, but from a wide range of sources of international law. It also supports the view that both states and supranational bodies have what has been described as a shared responsibility for implementing international human rights standards, decisions, and judgments. So, to conclude, the research supports the argument that discussions on the lack of enforcement mechanisms for supranational human rights can be a distraction to what happens in practice. Based on our findings, we concluded that one of the most important roles the African Commission and other human rights bodies can play is to enable and mobilize others to induce implementation through greater dialogue, broad dissemination of their findings, and strategic institutional and domestic cooperation. Now, in my current role, I don't use the term rules-based international order. I was thinking about what I draw on, and it is a whole range of international law and standards as evidence of what is expected of states to protect, respect, and fulfill human rights. So I'm going to leave my presentation at that, but hopefully that's given you a flavour of some of the research that I've been involved with. And thank you. Over to you, Roger.
Debra, thank you very, very much. That's excellent. Thank you. I guess the main takeaway there is that potentially certain non-binding standards, guidelines, recommendations, etc., might be considered part of the rules-based international order. I guess my response would be then they're not rules. They may be very, very useful, but then why are we talking about rules? So this brings back to a general question, and with Graham Melling's permission, I will fold his question into my general question. And I'll ask this to each of the four speakers in turn, 1 minute each, hopefully. Is there any value from the perspective that you have given us, so whether it be the contribution of regional systems to general international law, whether it be the relationship between UNCLOS, customary international law, and the behavior of states more generally at sea, whether it be the non-binding, binding divide, or in Kenneth Chan's case, more generally, I guess, the question being whether the rules-based international order undermines international law is a selective approach, as you have perhaps suggested and Graham Melling suggests. The general question to all of you being, does speaking of the rules-based international order rather than international law add anything of positive value to the discourse, or is it only going to weaken international law? Kenneth, first over to you.
Yeah, I mean, that's obviously a very big question. Yeah, I mean, I think it does, but it really depends on your perspective. If we think about what the rules-based order is really based upon, I mentioned that it's really about a community, or imagined community of states which are built on certain sort of universal public global public goods that we generally would consider quite desirable, like the rule of law, and these are all good things. The issue is really about the implementation, about the process through which a rules-based order presents this. I think in Graham's question, he mentioned, is it just a rhetorical device to legitimize that kind of behavior? And I think the answer to that is it might, and the most sort of critical perspective is that it might be a little bit worse than that, because what we're concerned about is not that it's trying to legitimize it, but it's trying to replace that regime altogether. And so there is not sort of a contestation there, rather, but instead saying, well, this is really the only way that you can look at these things. For example, the US has been a very strong advocate in regards to the right to use force in self-defense against non-state actors, and it's the liberalization of that particular rhetoric would have a completely different implication under the rules-based order than it would in the international law. There would be no sort of contestation anymore. So I think it is something that we have to be sort of careful to balance, because the rules-based order, as I mentioned, one of the really key issues there is that it's resistant to the idea of a consensual structure of international law. It doesn't want to commit to something where every state has participation or role in that conversation about what applies. And so even if we consider that the aspirations of the rules-based order to be quite noble, we should be cautious about what that means for global stability.
Okay, great. Excellent. Well, that's a very clear answer to the question, which I guess is it can add positive value, but we have to be cautious and careful. Yurika Ishii, does the rules-based international order discourse rather than international law add anything in the context of the law of the sea?
Thank you so much. So I will stick to the law of the sea discourse to answer your grand question. My short answer is yes. The rule-based international order adds the fundamental value to the legal order at sea, because if you look at the development of the law of the sea, there has been, as has been already mentioned, the resistance against the consensual regime, and also the states who would like to claim the maritime entitlement in excess of the international law rules. So we are looking at the politics that has been shaped the development of the law of the sea. And I would argue that the rule-based international order will give the guiding principles of the states, and also it will serve to the peaceful settlement of disputes of the international conflicts. When it comes to the global arena, like maritime space, or we can even talk about the global domain, such as cyber or outer space or whatever, there has been the power contest among states. Basically, the stronger states would more claim more entitlement to the global arena, and I believe that international law serves the critical role to give the fair share to the other states which do not have a similar power, and also it will give the equitable and fair benefits to all the states and also the international community as a whole. So I will stop here. Thank you.
That's a positive assessment then of the application of the concept to your area. It's interesting you mentioned maritime zones, because of course that's an area in which Latin America led the way, which then segues nicely, segue being also a Spanish word, to Kathryn Nash. Does the rhetoric discourse of the rules-based international order add anything in your context?
Yeah, I think it does. I mean, looking at public international law, that's something that probably develops over time into a conception of kind of hard law, or law that's understood by everyone if it ever develops in that phase. And so the rules-based order, I think, helps I think it helps with the creation of new law. And I also think it helps us to understand the current law. Just looking at what I mentioned when I spoke, the UN Charter, there's a lot of ambiguity in that and how we handle peace and security. Looking at the role of regional organizations, and then looking at the UN Security Council and how those actors work together. And I think the aspects that I spoke about in terms of kind of a de facto division of labor between the AU and the UN, the UN framework for possibly funding African peace missions, all of that I would view as kind of falling under this concept of a rules-based order, and that helps us to then understand the application of international law. So I would view the two as very much kind of complementary, and that you would have to speak to them together to get a full picture, actually.
Okay, great. Again, a positive assessment. Debra Long, in your context, does the rules-based international order as a concept, as distinct from international law, add anything?
Yes, I mean, I guess like the other presenters, I think it could be useful if we view it as Kenneth described, in terms of trying to capture a whole range of different instruments, whatever their legal status, that are trying to encourage state practice to respect human rights. So I think that could be useful. I think it is perhaps a distraction, because I think we used to talk about a human rights system, and I think that seems to have dropped out of people's speech now. So we're not talking about human rights systems necessarily, but there does seem to be this rule-based international order or public international law. But I think certainly what we need to do is recognize a whole range of different documents and different mechanisms that have been established and continue to be established and grow. As Kathryn mentioned about the sort of evolution continues to happen in order to try and improve the respect for human rights on the ground, and really to try and address that. I think I am concerned that it's being used to circumvent human rights law, or to undermine it, or even ignore it. I think that is a concern. For example, with the UK Rwanda bill, certainly the Law Society takes a position that that undermines rule of law. It undermines human rights law. I would also argue that it would undermine anyone's interpretation of a rule-based international order as well. So I think the way in which it is being used in the rhetoric is a concern. But I think if the appetite was for it to be better capturing the whole range of different instruments that actually in practice do impact, hopefully in a positive way, on state behavior, then that could be useful.
Great, thanks. Well, picking up and slightly reworking a question which has been asked online, which stimulated a question in my head. perhaps first to Kenneth, but also more generally, because Kenneth, I mean, in general terms, you may be more up to speed with the discourse. I guess one potential use of the concept of the rules-based international order is to capture certain, what might loosely be called rules emanating from the private sphere. So, for example, agreements among major corporations and governments in relation to the regulation of artificial intelligence, or to hate speech online, certain things like, for example, you know, the Meta Board of Control and so on and so forth. First to Kenneth and to others, I mean, is there any indication that the rules-based international order discourse is in some ways going hand in glove with discourses of speaking of global rather than international? In other words, incorporating certain norms which emanate from the private sphere, particularly the corporate sphere. And if so, is that a positive thing or not? So Kenneth first, and then others if they want to chip in on that.
Yeah, so I can't speak specifically about engagement with private law sphere, though I think it is an interesting thing, because even if there is engagement, and there is likely going to be some borrowing of norms and ideas from different regimes, it is always going to be something that's filtered through the perspective of this rules-based order. So it's going to go through that same process of organization, of hierarchical dispute, of contestation that happens within the rules-based order and within a context that we know really nothing about. When we know how international law is made, we know what that sausage looks like, and the rules-based order, we're very uncertain about it. So even if there is a lot of engagement with different norms, we would never really know about it unless they told us. And what we found is that when states refer to things about when they refer to the rules-based order as sort of a point of reference for why a rule or behavior is being accepted, it really is just on a case-by-case basis. It really seems to me like, oh, we spot this problem, and therefore we decide based on whatever process that we have to gather these norms, and then we tell them that this is the norms of the rules-based order, and that's, I think, the greatest concern. There's a lot of confusion around how norms are integrated. So I think even if we aren't looking at rules-based order strictly, we already saw this confusion surrounding norms, and for example, how the international community engaged with the responsibility to protect in the early 2000s. How much of this was law? How much of this was just political? How much of this had this degree of normativity? It very much is. We are strengthened by the process of international law. International law defines and it gives specificity and it gives stability in a way that rules-based order has yet to prove that it is able to do. And I think that's probably the bottom line of how norms are integrated within the rules-based order.
Okay, thank you very much. I don't know if any of the other speakers wants to add anything as to the possibility of, say, standards, I guess that's a better way of putting it, than rules developed in the private sector and their potential integration into some concept of the rules-based international order, either generally or in the spheres with which you are familiar. Anyone have anything to add? Feel free to say no.
May I then?
Yeah, sure.
Well, I do have. Yes, so I'd like to make a brief comment on that, because basically law of the sea is quite state-centric. The law has been developed through state practices. However, there are so many issues that has not been covered by the state-made laws, and I believe that the private entities and corporate standards plays a significant role in that for that purpose. So example could be environmental protection, development of for instance, continental shelf, the protection of submarine cables, and even the fisheries regulations have some impact from the private practice. So I'll just add that examples to the comments. Thank you.
While you are there, we have a question towards what you spoke about earlier, which really, in a way, hits the nail on the head. Could you explain just a little bit further what impact you think the Nicaragua-Colombia case will have on the concept of rules-based international order at sea? Because the question asks, you seem to be suggesting that the judgment gives preference to customary international law over UNCLOS, and is this synonymous with creeping jurisdiction that might affect the rules-based international order at sea? If you could just briefly reply to that quite specific question.
Thank you so much. So that was specifically my concern. As I looked closely at the text of the judgment, I believe that the judgment does not give preference to customary international law over UNCLOS. However, the relationship between the CIL, customary international law, and the UNCLOS that was assessed in the before the ICJ requires close examination. I think there are several ways of interpretation on this judgment. So my concern is that some country might use this judgment to claim the so-called creeping jurisdiction in excess of the rights and obligation under UNCLOS. However, I think there are the way to interpret the judgment that the ICJ did not went that far. Thank you.
Okay, well, that's a nice, concise answer to that question. Final overall question to everyone, perhaps taking it in negative order, starting with Kathryn. Starting with Debra, then Kathryn, then Eureka, and then wrapping up with Kenneth. Is the language, the discourse, the rhetoric of the rules-based international order ultimately just a way of undermining the sovereign equality of states and the requirement of state consent to the binding quality of rules of international law, something of the pick and mix approach that has been suggested? And if so, is this undermining of the sovereign equality of states, which is inherent in the requirement of, the notion that the sovereign equality of states is inherent in the requirement of consent, a good or bad thing for international law? Debra, briefly, 1 minute.
Okay, great. Yeah, it's interesting really, because I guess in terms of the way that we're seeing that the rules-based international order phrase being used is probably more for states to really try and enforce their sovereignty. So it's actually perhaps sort of a different way around really. As I mentioned, also concerns around then using kind of very old arguments about sovereignty and rights of sovereignty within a human rights sphere in order to try and sort of undermine or even ignore those human rights obligations. So I actually see it more being used, I think, by states in order to assert their sovereignty in perhaps in opposition to what we would be trying to try assert would be like the human rights law. So that would be my sort of perception of it.
That's fascinating. In other words, it's a use of the discourse which perhaps its originators would not have intended. Kathryn, do you have anything on that?
I wouldn't see the rules-based international order any more kind of problematic for state sovereignty than public international law. For instance, looking at the Inter-American system, there has been, I think, criticism recently of the court of the use of conventionality control, which is, I think, a very, it's an attempt to be very robust in how their judgments are implemented. And even though states have kind of opted into this treaty and opted into the jurisdiction of the court, there's concern about a mechanism that the court has developed for enforcement. And so I think that's a concern about, state sovereignty, and there's been criticism of kind of overriding consent. So even within international law, I think you have these concerns, and it's a constant kind of conversation between the rules or the law that we come up with as an international society, and then the ability of states to make decisions.
Okay, so it's no worse than the usual discourse we have, and that discourse is an ongoing conversation, and ultimately, I guess, a fertile one. That seems to be the take for what you've said. Yorika Ishii, rules-based international order undermining the requirement of consent to the binding force of rules of international law?
Well, I think there. How to say that? I'd argue that it does not undermine the state consent-based system under public international law. I think that international community, which is mostly not simple aggregation of sovereign states, but also the community requires certain principles and value-based foundation. And I think the rule-based international order could be one of the models that could serve as the foundation of international community. And of course, some countries might have the disagreement on certain direction. However, we do have the forum for the dialogues and the opportunities for those states to give their to express their views, and I think those sort of dialogue or the discourse should be made based on the certain legal order that could be the basis of public international law.
Great, thank you, Kenneth. You started, you finished. The idea being that you are the one who kind of framed the debate, and I guess can put the finishing touches on that frame.
Yeah, thank you very much. I was thinking about what Debra was saying in response to this question, and it struck me sort of when we talk about sovereignty that this conversation is happening while at a point in time where sovereignty has been dramatically reframed. This idea of sovereignty as responsibility, Francis Ding, that kind of thing, and I was thinking also, the US has at one point in time framed itself as sort of the global policeman of the world. And I think the rules-based order is sort of an extension or a continuation of that narrative. And in many ways, when we talk about what the rules-based order is trying to do, it is we find that that this is probably an idea that has been pushed the more that other states find themselves being derelict from their responsibilities to, for example, their own people. So in that sense, sort of the rules-based order, I think, finds increasing purchase as other states fail their responsibilities or under that notion of sovereignty and as responsibility. So I guess I mentioned already my perspective on the consent-based structure. I think that it is in many ways antithetical to what the rules-based order is trying to achieve. So I won't necessarily repeat that again, but what I will say is I really think that this is these kinds of conversations that we're having, and again, many thanks to Bickel for hosting us, are exactly what we as international lawyers should be doing to push back on that encroachment of international law and the consensual structure of international law, because we should be interrogating claims made by the rules-based order very vigorously. We should be asking why are these rules being applied? Where are they coming from? And we should also be very critical when states themselves don't apply the rules to their own behavior, because I think that weakens the way that the US, for example, defends the rules-based order when it can't be, when it is in many ways sometimes hypocritical in its own application. So I just want to close by thanking Bickel again for this really fantastic conversation. I think this is exactly what we should be doing in regards to engaging the rules-based order.
Excuse me, before we finish, sorry, Roger, I'd just like to ask if there are any questions here from the participants
that
have joined in person.
Thanks very much. It's a fascinating discussion. Stephen Haynes, I'm Professor of Public International Law at Greenwich. First of all, a comment on the rules-based international order, which I believe was invented within the Beltway in Washington by the think tank community, largely as a tool to hit the Chinese with. It was taken up in large measure by the Australian government in policy documents after the current Chinese leadership took office and increased its maritime focus, particularly in the Pacific, South China Sea, etc. So I don't see it as being anything more than a rhetorical device, as one of the questioners on the online community suggested. It's very intriguing to me, and Ken mentioned that as far as he was concerned, the first time it was used was in relation to the 2003 invasion of Iraq, which seems to me to have been an example of the rules-based order being pushed aside for political convenience. And I think most international lawyers at the time, including the deputy legal advisor in the British Foreign Office, would have taken issue with the notion that the invasion of Iraq in 2003 was lawful. So how that squares with the so-called rules-based international order, I find very interesting, and the debate is clearly going to be around that sort of thing. But the other thing that I wanted to point out in relation to something that Debra mentioned and talking about soft law instruments. Roger, you suggested that soft law was not law, therefore it wasn't really part of the rules collection. I see soft law as a means of perhaps using legal arguments, but also arguments of what might the law develop into as a way of changing state behavior. I've been involved in 3 soft law processes over the years, one of which was the Responsibility to Protect process back in 2000, 2001. And the other 2 were the Safe Schools Declaration. I was the author of the guidelines at the heart of the Safe Schools Declaration, now endorsed by 119 states. We would never have got a convention on the protection of schools. A soft law process was part of the way that we were going to achieve some measure of international agreement in relation to the protection of schools in conflict zones. And currently I'm pushing forward something called the Geneva Declaration on Human Rights at Sea, which is another soft law instrument, which we're trying to use to generate a shift in practice on the high seas and elsewhere. And I learned just a couple of weeks ago that the European Union has in fact taken one of the things that we've been recommending, which is that human rights standards should be enforced as a condition of the issue of fisheries licenses, as a good example of an idea that is commencing in a sort of soft law sense, but is actually having some eventual shift into state practice, which could, of course, eventually evolve into, Roger, clear international law. So I think soft law is a very, very good instrument for using as a means of shaping state practice. It's not perfect. There's no such thing as a perfect process of law creation in the international system. But I think it's got a role to play, and I think it's something that we should focus on. Thanks a lot.
Thank you. Yeah, no, I wasn't denying the role of soft law. I was just questioning, therefore, whether we could speak of soft law yet as rules, but by no means am I undermining or seeking to question its broader normative value, including, as you say, in shaping behavior, which may eventually lead to the creation of a rule of customary international law. So thanks for your comments. Absolutely spot on, very interesting contribution. Yolinda, Iris, I'm not sure if you want to add anything. I will just say from my
There is
point of
another
view.
question, sorry.
There's another question. Great. Yep. Yep.
Or comment.
Or comment.
I'll make it short. My question is to Kenneth, who characterized the international rule-based order as being based on Western values. And perhaps he made a distinction between public international law and the international rule-based order on that basis. As an international lawyer from the global south, I would characterize the whole of public international law as being based on Western values. So that's a bit of a problem for people coming from the global south. The other factor that I want to mention is as to the origins of this system. It depends very much on the area through which you approach the issue. So when you look at use of force, perhaps you could identify the justifications given by the United States as originating in the Iraqi war. But when you look at the area of foreign investment, with which I have dealt all my life, we have the rule of law argument trying to promote the protection of property or the sanctity of contracts being made from very early times, say from the 1960s. So this rule of law argument or a rule-based order is something that has gone on perhaps from rather distant times. Thank you.
Wonderful, excellent. A more long-term historical perspective on what seems from the question to be considered a Western construct, but then equally from the question, no less so perhaps than public international law itself. I can't see any other questions, so Yolinda, you'll have to guide me on that one.
Yes, so thank you so much for the super interesting discussion. We are a little bit over time, but we have the coffees here. I think just a few minutes, we prepare for the next panel. For those that are here, feel free to have a coffee, and in the meantime, we will prepare for the next panel. Thank you so much to the first round.